Good evening, this is John Milburn for LAWS12062, Alternative Dispute Resolution, and we're into week 3, term 2, 2019. Thank you so much, those that have joined live for the session. I really do appreciate it. I'm going to immediately start the share and invite you to look at the material in week 2, I believe, that relates to applied skills in mediation and conciliation. And this is something that I prepared a couple of years ago. So you'll see that this is something that relates to, sorry for jumping around, something that relates to a practical session on mediation and conciliation skills. So I'm not one for PowerPoints generally, but I will use the prompts that I've got. So feel free to call this up from your Moodle site if you haven't already downloaded it and follow with me. So the premise of this evening's session, which will probably go for 2 nights, is in relation to practical skills. This, of course, is directly applicable to the first assessment. And I hope that you can read the writing on the screen. It's probably a little small, but you do have it on Moodle that you can follow along. So what we're looking to do is encourage you to create or supplement checklists that you might use in the conduct of a litigation matter. In this particular context, in relation to mediation. Now, I do like checklists. I think that checklists can be very useful. Part of the reason for that is that it takes away a lot of stress. Now, when you're preparing your material for the first assessment, I suspect by now you've already got your opening statement just about completed. You're probably going to use some sort of dot points or checkpoints to ensure that you've covered everything. If not, if that works for you, then please start commencing that process. However, as you might expect, there's some planning and preparation required. So much of what I'm going to talk about this evening relates to that process of planning and preparing and implementing various strategies and techniques. So this is designed for legal practitioners that are looking to assist a party involved in a dispute that lends itself to an ADR option. And some of these techniques can actually be used by ADR practitioners during the course of an ADR session. So it'll come as no surprise that what we're talking about tonight is something that we want to adapt so that you can use it as an ADR practitioner, as a mediator or conciliator. However, particularly for the purpose of the final assessment and also gaining the most from this unit, I'd like you to look at what we're dealing with tonight and next week in particular in the context of how you go about advising a client that is considering an ADR option or moving into an ADR activity. So I'll return to the share. And as usual, if you have any questions, please ask as we go. Use the chat facility or simply unmute your microphone. If you understand and can practice as an ADR practitioner, you'll be in a better position to advise your clients about ADR options and ADR processes. In other words, you'll be able to use some of the techniques to your client's advantage. So, for example, if you're preparing a domestic violence application before the presiding magistrate, your client may find him or herself in the preferred position from the outset. For example, if you were to make a comment, my client understands and embraces the concept of mediation and respectfully asks for an adjournment to enable the parties to make appropriate arrangements for a mediation session, you will receive congratulations more than likely from the presiding officer because you've immediately identified mediation as a way of dealing with this issue. Now, I know what some of you might think. Domestic violence issues don't necessarily lend themselves readily to mediation because of a power imbalance between the aggrieved and the complainant, or the respondent rather, in those circumstances. And I hear you clearly, and power imbalance is one of the matters that we need to deal with. One thing that's often overlooked, and one thing that I want to stress in the context of ADR and the study of law generally is you having an ability to identify how the Australian Solicitors' Conduct Rules or the Barristers' Rules do apply in certain circumstances. Also, the Legal Practitioners Act. In other words, whenever you're considering any legal advice or answering a legal question in whatever subject it might be, always consider the ethical duties. And if I'm marking an assessment and I see that someone has identified an ethical issue and raised a specific concern or solution, then so much the better, and it puts you into that much higher standard of work. So even if you're not asked to provide some information about ethics and ethical rules or conduct rules, I would urge you to at least consider that and possibly introduce something. Now, I've suggested here that we need to leave your adversarial hat at the door when you walk into an ADR process, because ADR is alternative dispute resolution, and we're really talking about ways of dealing with an issue other than traditional litigation. Would I be correct in assuming that all of you have found information from NADRAC, which was the former body that is now defunct, but still remains an authoritative source of information in relation to ADR? Have you found that? So there's quite a lot of reference to NADRAC, the National Alternative Dispute Resolution Advisory Council, which was a federal government initiative that fell by the wayside, but it still has a lot of ongoing benefit. So you can find that material still in textbooks and on websites. The reason I'm showing you these definitions now is that if you're going to undertake for your assessment mediation or conciliation, a pretty logical starting point is to have a clear idea of the definition and to work within that definition. So, for example, in a pure facilitative mediation model, the mediator has no advisory or determinative role in relation to the content of the dispute or the outcome, but may advise on the process. Having said that, in addition to a facilitative mediation, there is the option of having an advisory mediation, which is very close to a conciliation in that you can then advise or determine the process. So there are different definitions that apply. And what I would ideally like you to do is identify in the brief overview of the mediation or conciliation session that you're going to provide for me as part of your assessment, some idea of what it is that you intend to conduct and how you're going to go about that process. So very briefly, if you're purely going to approach this as a facilitative model, let me know. That way, if you lapse into advisory mode, it's probably not a good look, and vice versa. I'll stop the share again for a moment. From a practical perspective, this is important because if you're an ADR practitioner, you're setting up a mediation or you're setting up a conciliation, as part of the intake, you need to explain to the participants what it is that you do, what's your role, how you go about your business, so to speak. And they can then understand that if you start to provide some degree of advice, probably in private sessions, they were expecting that because you told them this is the model of the mediation or the conciliation, and it's part of the mediation or conciliation agreement. Likewise, if they're expecting you to provide them with some advice and you just don't, then they may leave the session disappointed and frustrated, thinking, well, we paid all this money and the mediator didn't even help us to settle this matter by providing some advice or some feedback as to our prospects down the track. So it's a matter of meeting with the expectation of the participants, and when you set up your mediation, let me know what model you've selected so that I can mark you against the model that you've identified as being the one for you. I hope that makes sense. Any questions? All good? All right, we'll continue the share. So you'll see there the distinction between conciliation and mediation. However, these are softer boundaries is probably the term that I could use, because you'll often find in mediation that essentially different terms can be used for the same thing and vice versa. Now, as you would have, as you'd recall from your textbook and our first week, there are different modes of ADR, and the 14 that we've taken there are from Spencer's book. Negotiation being the most informal or consensual or non-interventionalist model, to the formal non-consensual interventionalist model of arbitration, which is the most court-like. Just as an aside, if it were me, create with that same 14 list, I would reverse conciliation and mediation in the order. And the other thing is that early neutral evaluation is probably most commonly known as case appraisal. So if you've come across the term case appraisal in the UCPR, then that is really early neutral evaluation. So for the first half of the unit, we're really concentrating on the two in the middle, conciliation and mediation, even though I would swap them around in terms of where they fit. And for the rest of the unit, we'll be branching out and talking about the other 12. All good? All right, let's move on then. So the ADR process is conducted on the papers or with evidence hearing. So that is an early neutral evaluation or case appraisal. It's like a mini trial, it's non-binding, and the results are put into writing by the ADR evaluator, and it may assist in various ways. So that's a little digression there into early neutral evaluation and case appraisal. So case appraisal might assist your client to resolve the dispute, identify misinformation, the need for third-party expertise, or statements by a third party. Let's go down and look at some of the other notes more relevantly to our first assessment. Sometimes, and this is C, sometimes people use the term mediation in a broad sense. That is to describe a process where dispute resolution provides advice, which is really bordering on, if not conciliation, and it can be an advisory mediation or an evaluative mediation. Sorry to stumble. D, as a practitioner, you can use a range of ADR processes to assist your client, and that's often overlooked. Again, I know we're talking primarily about mediation and conciliation, but for the sake of the final assessment, be prepared to create hybrids or sequential models. So it may be, for example, that you believe case appraisal is ultimately the best way to resolve the particular dispute without it going to formal litigation. However, you may build in a model which involves mediation first and case appraisal in the event of an unsuccessful mediation session. But again, I digress. If you have any questions, please unmute the microphone, use the chat facility, otherwise I'll keep going.
I'll ask a question in regards to
Yes,
that.
indeed. Thanks, Leonie.
I know that you're talking about the final assessment, but just in terms of the assessment, the first assessment that's coming up, does all three members need to have the same model, or can each member use a different model?
That's a very good question. I'm glad you asked that. Everyone can use their own model. So in the group, you can have someone doing an advisory mediation, somebody else doing a conciliation, and someone else doing an evaluative mediation. So whatever you choose, it doesn't have to be the same. So the other two are there really to assist you in the process. But you're guiding the process and you set the rules and you identify what it is that you want in terms of the ADR session for your own assessment. I hope that makes sense. And for those of you that are not physically able to be in the same room, and I suspect that will be most of you, my suggestion is that you undertake the mediation or conciliation session via Zoom or some similar platform where you can record it using audiovisual techniques. So you don't have to be physically in the same room. Some students prefer that and video, if you like, the entire room. Others will conduct their session completely online. So can I just get a straw poll just to keep you busy a bit? How many of you are going to do this as a face-to-face assessment for assignment 1? And how many will be doing this by audio-visual? So F to F or AV. So online is 1 vote, AV, AV. Most of them are AV. Face-to-face, all right, good. So again, flexibility in terms of the model and your process. It's up to you to decide.
John, quick question
Yes.
on that. If we are intending to do it AV, is it worthwhile either in the premise or providing a diagram of how, if it was face-to-face, one would set up the room?
Oh, that's not a bad idea. I hadn't seen that previously, and you could perhaps even put that into your your 300 words. So maybe that's a possibility. But yeah, for some extra brownie points, that's probably a good idea. You don't have to. If it's AV, you don't have to. But if you want to add value add, then you can. I hope that answers your question, Jack.
Yes, it does.
Great, thank you. Mary says online. Yep. All right, good. So I'll just complete the share process now. So as a practitioner, you can use a range of ADR processes. And E, if the proceedings are on foot, meaning that they have started, the ADR process may be prescribed by the court or tribunal, but that doesn't preclude the parties attempting to resolve the matter through other ADR processes. That's often overlooked. People forget that they can remain creative during this process. Now, in addition to the 14 that's been listed by David Spencer, there are some other forms. For example, there's an entire range of specialist ADR processes available in certain circumstances. One example is the process of case conferencing in criminal law matters, and other ADR processes involve government or semi-government agencies such as the Ombudsman. So when we've identified 14, that is a non-exclusive list. There are, in fact, many, many more than the 14. But there are 3 basic types of ADR process. The first is to facilitate, where the ADR practitioner assists the parties to identify the issues, generate options, consider alternatives, and reach an agreement. So examples of that would be mediation and facilitation. And the second is advisory, which is the same as facilitation, but in addition, the ADR practitioner provides an appraisal regarding the facts or the law, or possibly comments on a likely outcome. So the typical example would be conciliation, but also case appraisal or expert appraisal. And the third type of ADR process is where one makes a determination. That is, the ADR practitioner evaluates the dispute, makes a decision, and in doing so may conduct the process as a hearing and even receive or call evidence. So examples, expert determination, mini trial, and the most common, arbitration. So do you understand that broad category where there's 3 different types of ADR processes? And in the first assessment, you're really limited to 1 or 2, but you get to decide where you fit within that continuum. In other words, there is no such thing as a model mediation. There are different variations and there are different ways of approaching it. Okay, thank you. We'll keep moving on. So,
John, can I just ask a question?
Yes, Mary.
Say if you were doing a mediation or something, say you normally use the whiteboard, and you don't have one, and like you're doing it in, so I'll be doing it here sort of in my office, right, with others online. Can I use an A4 side on and write on that, you know, hold it up to the camera as what I would normally put on a whiteboard, just as an example if I decide to use that?
Absolutely. Yes, you can do that. Or you can use the...
This is a whiteboard.
Yes, you can do that as a physical whiteboard, or you can use the share facility as we're doing tonight to flash back into, you know, as to set up the agenda items. So yeah, either of those would be fine, Mary.
Yeah, I'm just not that great at technology. I'll probably delete everything or something.
Oh, okay. No, I'm sure you'd be fine, but thank you. All right. So when you're advising a client about ADR options, the first question that really needs to be asked is litigation the most suitable method of dispute resolution, or can the matter be resolved through alternative dispute resolution? Many practitioners simply don't ask that question, but it's a critical threshold question. Now, sometimes the decision not to proceed to mediation is perfectly valid. In other words, just because ADR exists doesn't mean it must be used in litigation in every alternative. There may be good reasons to immediately and solely embark on litigation. So, for example, if the matter was urgent or there were serious risks for safety, or it may just simply not be worthwhile. You've got to be careful about the last one. It's one where it's just not worth an attempt, because some of the more senior practitioners who are much more accustomed to litigation than mediation will say, well, of course, there's just no chance this will resolve. But given that mediation has a success rate of, I don't know, 85% or thereabouts, there clearly are many instances of litigation where the parties had no real prospect, so they thought, of settling, but end up settling. So number two, lead by example. So this is really what I'm getting at in terms of your attitude as a practitioner to ADR, because your demeanor, your attitude will influence the attitude and behavior of your client. If you dismiss ADR, then your client might also become dismissive. But if you're enthusiastic and you embrace it, so too may your client. But again, this is often overlooked, and from a practical perspective, it's very important. Take written instructions and ideally have your client sign those instructions. So during this week and next week, we'll be talking about some of the advantages, disadvantages of ADR. If you're advising a client about these advantages and disadvantages and providing the client with an opportunity to provide instructions, then best you get those in writing and reduce your advice to the client in writing as well. But it's pretty obvious, isn't it, that in order to explain ADR options to clients, you first need to know what those ADR options are. I've said that there's at least 14, and I've identified more. So if you don't know about these ADR options, you can't very well explain them, which means that you can't very well obtain your client's instructions. So when you're advising your client about ADR, you need to consider a number of matters, including their personal circumstances, the nature of the dispute, type of proceedings, the statutory provisions, and the position of the other party to the dispute. There's some of the factors that you might consider. So when we talk about personal circumstances of the client, there are some questions to ask. Does your client want an early resolution? Sometimes they don't, but almost always people say, yes, I want an early resolution of the problem. You can picture a situation, can't you, where you have elected to proceed with litigation. The litigation has been conducted over a period of 2 or 3 years. It's been hugely expensive. On the day of the court, or the day before the court, the matter is resolved through discussions and the client is happy. But then asks the horrible question, why didn't we do this on day one? Why are we doing this 2.5 years down the track now that I'm $80,000 out of pocket? What answer are you going to give to that? If you've not considered ADR options, if you haven't encouraged discussions, then as an advisor, you've left yourself vulnerable. So you need to ask the question of the client, do you want an early resolution of the problem? And if so, how do you propose to, would you like me to advise you of different options? Do you believe that your client would benefit from reality testing that might be best served through an ADR session? When we talk about reality testing, we're really testing the boundaries of what is likely to happen in the event of proceeding one way or another. And clients aren't particularly good at reality testing. Some lawyers aren't good at it too, particularly if the lawyers, for want of a better term, fall in love with their case and think, we're on a winner here, I'm not even going to think about different options. But reality testing means asking the questions, the what if type questions. Another is personal circumstances. Does your client have capacity issues? Are you really satisfied that your client is capable of making proper or providing proper instructions? If not, there are some techniques to get around that. One is to look at obtaining instructions from a substitute decision maker, such as an attorney under a power of attorney, or an administrator or guardian appointed by tribunal, or perhaps a litigation friend. Next, are there family relationships that need to be preserved? If, for example, you're involved in a dispute or providing advice to a grandmother who is concerned that her grandson has failed to repay the $20,000 that she lent to him 3 years ago, the question is, would your advice be different in that situation than if you were advising a supplier of goods who had an unpaid debt of $20,000 in relation to those goods? So on the face of it, the dollar figure is the same, it's the same type of action, but you might want to consider family relationships and to see if they can be preserved. Does your client have any issues to do with capacity or language or cultural issues? And consider your client's time, money, and emotional and physical well-being. Sometimes clients just don't have the money to litigate and they need to find a way through to obtain an early resolution. Also consider the type of dispute. For example, if you're dealing with a potential breach of copyright or trademark case, then you may need to move swiftly through the court system, seeking injunctions, undertakings, and other techniques in order to preserve your client's position, as opposed to, say, a neighbourhood dispute that may not necessarily lend itself to immediate or urgent action. So you need to consider the type of dispute, the sensitivity of the dispute, and it may be that confidential resolution will assist the parties generally. Now, sometimes there might be a serious power imbalance, and I mentioned that earlier in the context of domestic violence. So if there is a serious power imbalance or a party is suffering acute distress, ADR could occur by way of shuttle, which is where the parties are in separate rooms and the dispute resolution practitioner moves between the parties rather than having them in a room. Now, the reason I'm stopping there is that you'll need to make a decision for your ADR session. And I'll upload this session later this evening. Thank you. Will you conduct your mediation face-to-face, as it were, even if it's online, with everyone in the same room, or are you going to have a shuttle? Now, a shuttle situation is where one party is remote from the other. My strong recommendation to you is that for the purpose of the assessment, you conduct a face-to-face mediation. And when I say face-to-face, I'm really talking about face-to-face physically or face-to-face in the audio-visual space, as opposed to a shuttle, which is where the mediator only talks to people in private sessions throughout the whole mediation. The parties never come together in a joint session. It's a model that some mediators and conciliators like. My personal view, I'm not a fan. And wherever possible, I try to avoid a shuttle situation. I think it provides generally a better result. So any questions about what I mean by shuttle mediation and why I'm encouraging you not to do that for this assessment? All good? All right. Go back to the shared space. So you need to understand the nature of the proceedings. For example, a youth justice conference or a family group meeting is passive as a lawyer. So when we talk about youth justice conferences or family group meetings, we're talking about different ADR processes that are specific to, in the first one, crime involving juveniles, and the second, conferences involving members of the Department of Child Safety and family members, parents typically, in a family group meeting. So lawyers are quite often attending these, but sometimes their role has to be passive. So under legislation, sometimes you're there to assist the parties, but not dominate the process as some lawyers want to do. You also need to understand the statutory provisions relevant to ADR. So there's a Section 60I of the Family Law Act provides for the issue of a certificate before some matters in relation to, say, parenting can become the subject of litigation. And also do look at the Civil Dispute Resolution Act, and you'll see there a case in the federal court where a party's failure to meet their obligation to take genuine steps was held by the federal court to be a serious matter that would go to the question of costs. So it dealt with a claim under the Civil Dispute Resolution Act, Commonwealth, 2011, and there was an issue of costs, and the court said that the object of the Act is to ensure that as far as possible, people take genuine steps to resolve disputes before civil proceedings are instituted, and they must file a genuine steps statement at the time of filing the application. So I mentioned earlier that on occasion there are practice directions or specific pieces of legislation that require you to undertake some ADR before proceeding to court, and there are two examples, both in the federal sphere. Also in the Evidence Act, 1995, Commonwealth, Section 135 deals with the issue of excluding confidential nature of discussions during mediation or conciliation. So that's a specific statutory provision, but it's a general requirement of ADR. And there's some statements there about when the court may refuse to admit evidence in certain circumstances or allow for some introduction of evidence in other circumstances to resolve issues of something that might be misleading or confusing. In the state jurisdiction, we have the UCPR, Section 5 deals with the philosophy, the overriding obligation of parties in the court, and do have a look at Chapter 9, Part 4, that deals specifically with ADR processes, and you'll see it sections 313 to 351 of the Queensland Uniform Civil Procedure Rules. So even for the first assessment, I would recommend that you look at some of these rules. It won't be something that is particularly relevant to the first assessment. It's more incidental in terms of its relevance. But these statutory provisions, practice directions, rules may be highly relevant for the second assessment. So that if, for example, you're called upon to advise a client in relation to process, it might seem easy just to say, well, I recommend mediation, full stop. But you need to understand the statutory provisions and blend those provisions, those obligations, into your advice so that you're also dealing with a range of options and ones that work within the context of the statute and the rules. I hope that makes some sense. All right, let's go back to the share. So all of these things are matters for your discussion with clients about ADR. You've got a number of opportunities to raise issues, and you may wish to speak to your client about the nature of the ADR process. So your clients won't necessarily know what it's all about, and they won't necessarily know how they should act. So let them know that many of these processes are not investigative or inquisitorial, and it's not necessarily a matter of determining who's right and who's wrong, but rather the overriding philosophy to work towards a negotiated agreement. And that's the sort of thing that you might cover in your opening statement for your mediation or conciliation. One thing that could be very useful when you're providing advice to a client or preparing them for an ADR session is going through a role reversal process. So if, for example, your client is in an entrenched position or unable or willing to consider the dispute from the perspective of the other party, then perhaps you can, as it were, attempt to have them step into the other's shoes and get a feel for what it would be like from the other side. You might have already picked up that that's a useful technique as the mediator or the conciliator, particularly in private sessions. Trying to have the participant who is not budging consider things from a different angle is always a good technique. There may be requirements under statute to provide a formal advice in relation to likely outcomes or costs associated with litigation. So when you commence these discussions with a client about ADR options, you're actually engaging in some genuine reality testing. And if the client becomes aware that failure to resolve the matter at mediation is likely to involve then protracted litigation and substantial cost, with that reality in mind, you may find that your client suddenly becomes far more cooperative and engaged in the process. Likewise, if you're the mediator or the conciliator, you might wish to ensure that the participant is aware of those matters and is aware of the risk and the costs associated with it. I'm just going to stop the share, see if anyone's done some forward reading now. There's a couple of acronyms that deal with this issue about inviting the client, the participant, to think about these alternatives from the perspective of what may go well and what may go badly. Has anyone come across these acronyms? No.
Is it BADR and WADR? Best possible outcome and worst possible outcome?
Exactly. Very close. The WATNA and the BATNA. Thank you, Jack. So you need to consider the worst alternative to a negotiated resolution and the best alternative to a negotiated resolution. Yes, Mary. Thank you, Jack.
Oh, sorry.
No, you're right. You're right, Mary.
Sorry, I was just going to say BATNA and the, like, just write the initials, and I was going to say it. Someone else was saying I was going to write it, and then.
Right, that's it. The BATNA and the WATNA.
To unmute, but yeah, BATNA, I keep thinking Batman, and WATNA, I mean, I'm just trying to think ways to remember it.
So it's the best alternative to a negotiated agreement or the worst alternative to a negotiated agreement. It's a very important part of reality testing, and one that you probably want to embark upon with your client before you go into a session. Now, if you're the ADR practitioner, you probably want to somehow introduce this into the discussion. So make it obvious that you want the clients to consider these. If they've done their preparation for the mediation or conciliation session, the client will know these things. Otherwise, it's certainly part of your task to assist with this reality testing. The discussion will need to involve a candid statement by you in relation to the cost of litigation and the risk of litigation. As you're preparing for an ADR session, you might want to use it as a forum for presentation of a case and get an idea of how the matter would proceed to litigation. So you'll need to also then consider what evidence you or your client must obtain and when and how to do so. A lot of people don't do this. A lot of people think, oh, well, we'll just go to the mediation and we'll just see how it goes. That's a very poor way to approach a mediation. I've just highlighted one thing that you can do there. The first is this. If you're advising a client about ADR options and you go through this process of reality testing, the BATNA, the WATNA, the worst case scenarios, if you do a mock presentation of how the litigation might go, the penny might drop between you or your client or both of you in relation to certain key aspects. For example, it may become painfully obvious that in order to win this litigation, you need to have an expert, an expert report. So the question is this: if you're preparing for mediation and you know you're going to need it for litigation, should you pay the money to obtain the expert report before you embark on litigation, on mediation? So rather than think, oh well, we'll just turn up and we'll see what happens. Here, get your expert reports, get your witness statements, have your witness or your client proofed in terms of his or her evidence. Prepare a statement, an outline or a position statement for the mediation. So these are all important things that you can do by way of preparation. And if you think through what you might do to prepare for the mediation, that will put you in a better position if you are in fact the mediator. So explain the likely cost and timing associated with an ADR strategy. Explain what might happen if the matter proceeds to ADR, and then explain what might happen if it doesn't proceed to ADR. And reassure that your client that the aim of engaging in ADR is not necessarily to reunify a relationship or refresh a friendship. Sometimes people think, oh, I don't want to go to mediation because I don't want to have anything to do with that person. If you get that sort of response, then the way that you might deal with it is to say, well, it's not about that. What we're looking to do is deal with the issues and come up with a solution to the problem. You don't have to become best mates with this person with whom you're disputing at the moment. So think about the best resolution for your client. Ask if your client has a preference and see if they want an ongoing relationship, but then ask some basic questions. How much time and money do you want to spend on this litigation? How much control do you want over the process? And then ask, how structured does your client want the process to be? And do you need to encourage your client to enter into dialogue with the other party. So again, we're looking at this from the perspective of advising a client going into ADR, but I'm sure you can see that some of these things are matters that need to be discussed with or raised as the ADR practitioner. So when we get to the mediation or conciliation session, your client, if you're advising a client, needs to understand your role as a practitioner in the ADR session. So if you're the lawyer representing a client in ADR, you might want to talk tactics with your client. Are you going to speak, or are you going to encourage your client to speak? Will your client extend an offer, and if so, will it be the opening offer? And does your client need to make a preliminary inquiry or obtain preliminary approvals, for example, for funding? Understand your client's role in the ADR session. And the main rule is that this is the client's dispute, and do take care not to take that dispute from the client. Understand the role of the ADR practitioner. So this is you for the first assessment. And you can see there the cartoon, the caption. First, can we agree that this is a big backyard? So looking for consensus is a very common way that mediators try to break into some meaningful dialogue and have parties make concessions. So then prior to the mediation or conciliation, the ADR practitioner may be in a position to assist the parties. There may be face-to-face or telephone intake, but that doesn't always happen. So when you're deciding upon your mediation session, you need to decide whether you're going to have some form of intake, and if so, how that's going to occur. Given you've only got a limited time, my recommendation is that you don't actually record any form of intake. You can if you want, but it's going to cut into your time dramatically. In your opening statement, you could refer to the fact that you've already engaged in an intake process with both parties, and as you made it clear at the time, that was regarded as the first private session, and nothing that you discuss with the parties during that intake will be discussed by you or disclosed to the other party during the ADR session. But my recommendation for the first assessment is essentially embark straight into the ADR session without the intake. Any questions about intake or preparation so far? All good? All right. Now you'll need to advise your client as to what's going to happen during the course of the mediation. Or if you are the mediator, you might want to include some of this in your opening statement. Now I've suggested that if you're the advisor to a client in ADR or going into ADR, it would be useful for you to understand what the mediator or conciliator will attempt to do. So I'm using the terms effectively interchangeably because they're very similar. But a mediator will attempt to do a number of things. And as a legal representative, you can consider also using some of these techniques. It's often advantageous to do so. So one of the first rules for the mediator is to attempt to focus the attention of the parties on the issues and the problem. So what you're looking to do is have them be less focused about each other and personal disputes and more focused on what are the real issues, what are the problems. And that's part of your agenda. So in the ADR session, I'd expect that you'll come up with an agenda item list. It might be 2 or 3 matters, but some sort of agenda which is really encapsulating the true issues of the dispute. Number 2, the mediator will seek to allow the parties to retain ownership of the dispute. And the mediator will often use the lawyers who represent the parties to his or her advantage. I certainly like it when lawyers are representing parties at a mediation or conciliation. The mediator will need to be energetic and alert. So when you're doing your first assessment, you need to be really working hard, active listening, and Judge Kingham said, remain light on your feet as a mediator. So not slow and ponderous, but energetic and alert is a very good way of approaching it. Now, there are some very successful mediators and conciliators that are very measured and relatively slow in their approach. So there's not necessarily one way that will fit all circumstances. But if you can think of that phrase, remain light on your feet, I think that's a good mindset to adopt for your mediation or conciliation. What you're looking to do as a mediator or conciliator is this. You may find that the matter gets bogged down, and it may be that people are not able to make the sort of compromises or create opportunities for resolving the matter in the way that you'd like. So sometimes you need to stop a certain avenue, refocus, move on to something else, and then come back to it. Another really important thing to have in your toolkit, as it were, is the ability to listen for individual words or phrases that might just be something you can work to your advantage. And by that I mean, sometimes people inadvertently or intentionally say something that allows you to seize upon it as a way of attempting to resolve the matter. I know that's a bit abstract at the moment, but what I mean by that is be very keen to actively listen so that you can better provide opportunities to assist the parties to resolve. So when you're mediating, what you're looking to do is come up with different ways of moving forward. You'll need to go to your toolbox. You'll need to learn how to rephrase or to summarize or to reality test. And ideally, these are the sort of things that you can showcase in your assessment. So I'll be looking for people that can do these, can undertake these techniques successfully. The mediator will work the agenda in a positive manner, keep the parties focused, and the mediator will try to obtain some general points of agreement so that the parties operate within a positive consensual framework. What does a successful mediator do? Well, firstly, attempt to identify each other's points of view. Secondly, remain focused on the task of resolving the dispute. And thirdly, try to find points of agreement. So the mediator in the first cartoon, can we agree? It's a big backyard. One practical technique that I use sometimes is if there is a map, for example, or a document or something which is common to the dispute, but it's in documentary form, I might lay it out in the middle of the table and have the parties focus their attention on the map or the document, whatever it might be. From a physical perspective, what they're doing then is they're moving forward and they're moving down and they're looking at something together. And what I'm trying to do there is from a practical and useful, in a practical sense, have them focus on something which is not each other in the dispute, but focus on something so that we're trying to get some point of agreement, and also trying to identify things from others' perspectives and trying to deal with the real issues. Now, a conciliator may have a backup plan that provides an assessment of the parties in private session as to their prospects, require the parties to work in identifying the material facts or legal issues so as to shorten and simplify the hearing of the matter if the matter does not resolve a conciliation. And then finally, the conciliator might make directions about the future conduct of the matter, possibly introduce an experts conclave or include an agreement as to material facts and relevant legal issues for determination by the court or the tribunal, and include an obligation upon the parties to comply with directions. So with that last part there, I've really introduced a segment about how mediation is different to conciliation. So with conciliation, given that there's this more advisory role, and if it's in the context of a court or tribunal conciliation, usually there's power upon the conciliator to make directions, and they might include to set up an experts conclave, which is where experts have to meet with each other without the clients, generally without the lawyers, and their role is to identify points where they agree, points where they disagree, and identify a list of things that need to be determined by the court or the tribunal as part of the fact-finding exercise. So that's the part of the difference between conciliation and mediation. All right, well, you've been very patient this evening. I know I've done a lot of talking. We have a lot to cover next week as well. We're just about ready to sign off, but before I do, are there any questions? Any comments? All good? Okay. All good, says Mary. Thank you. So does Peter. Okay, well, we'll wrap up for tonight. We'll see you next week. Please continue the reading. And next week, we're going to go into some of the practical techniques that you'll need to devise and implement as a mediator or conciliator. Summarising, reframing, detoxification, reality testing, all of those things. So do some reading ahead, try to understand the process, and we'll see you next week. All the best then. Bye.
Thanks, John.